Oh, we're recording. Welcome back, everyone. My name is Matthew Leffler. I am the armchair attorney. I love trucking. I love supply chain. I love trailers, flatbeds, reefers, chassis, dry vans, bulk. I don't know. I love those boxes. Everything that you love comes in a trailer. Big shout out to my sponsor today, my partner, DAT, helping truckers get home since 1978. Look, it's hard running a commercial fleet. It's one of the most dangerous jobs in the country, and yet it's one of the most common professions in all 50 states. Driving a truck is a noble profession, but it's challenging. Hard to find parking, hard to find bathrooms, and there's all the regulation all the time. But DAT is your partner. For many years, they've been helping truckers find profitable loads or just loads that can help you break even. This is a tough market to be in, as many of you know. Now, I am so excited today to bring on my very special guest, Brandon Wiseman. He'll be here in just a moment. I want to tell you a brief story. How in the world did a lawyer like me get into the business of law and supply chain? That's a great question. I began my career as a lawyer representing trucking companies and both private fleets and for-hire motor carriers in contracts, in acquisitions, catastrophic accidents. It is very challenging. When I went to law school initially, the one thing I wanted to do was be nowhere near supply chain. Having watched my dad work at Roadway and Airborne and his own company, Outsourced Fleet Services, I only understood transportation as what made Dad not around. It's a tough business. Sometimes you're on the road half the year, sometimes more. It is difficult even under the best circumstances. Safely delivering freight on time and undamaged is hard. And it's not getting easier. The reality is, I never expected to be at the intersection of law and supply chain, but that's where I found myself. And that's where so many of you find yourselves. I say this often, you can't opt out of the supply chain. You can't opt out of logistics. You need things on your doorstep or on the grocery shelves or at your local hardware store. Everything in the world comes on a truck. Maybe it's made nearby, but chances are it's made across the world, hopping into a container on a boat, to a dock, to a port, pulled off, put on a chassis, and brought anywhere in the country. That's what supply chain is all about. Getting things moved from one place to another safely and on time. But my goodness, are there a lot of things happening right now? I just got back from the American Trucking Association's Technology and Maintenance Council. This is the main event if you're a maintenance and safety person in our industry, because this industry is full of challenges. Now, I am excited. I love talking to people in supply chain. There's no doubt about that. But I absolutely love talking to attorneys. Attorneys have the best stories. We see the worst. We see the best. And my next guest, Brandon Wiseman, is the founder and CEO of Trucksafe, a consulting company that helps motor carriers stay compliant. It's an interesting business because the regulations, if you're not aware, are always changing. He's also a lawyer. Cut his teeth at Scope Elitis, one of the best law firms in this country when it comes to transportation. And now is a partner of the Childress Law firm. I am so jazzed. If you are watching this, we are streaming right now to Facebook, LinkedIn, YouTube, and Twitter. I can generally see your questions. If you have questions, please add them to the mix. We'll try to answer them. But let me introduce you to my very good friend, Brandon Wiseman. Brandon.
Matt, what's going on? That was quite the intro.
I am so excited to talk to you, man. How are you doing?
I'm doing great. I'm as busy as ever, which I feel like everybody says, but I feel like I am actually pretty busy.
This is an interesting time in the business. But before we get to like what's happening these days, how in the world did you find yourself in logistics?
Well, it was similar to your story. I grew up in it. So
Okay.
my dad was, before he went to law school, he was a safety director for a large fleet. And then he went to law school, and then he ended up working at Scopolitas.
Okay.
He's still there. And so he worked in the area of DOT safety and compliance. So I kind of followed in his footsteps, went to law school, ended up at Scopolitas, worked there for many years, and now I'm off doing my own thing. So
With your father, was he at like one of the big LTLs, like a yellow roadway or CF?
not that big. It was a large tank carrier.
Oh, that's a lot of compliance in the tanking
Yeah,
business.
it was hazmat issues and stuff like that. So
That's the stuff that keeps up safety directors at night, and compliance directors. There's no doubt about that.
yeah.
So you go to law school. What were you want to do? What was your plan? Did you have a plan? Like, what did you want to practice, or was it just more like this is the natural progression because Dad did it?
Well, a couple of things. So I always knew I didn't want to be in litigation. That was never my thing. I enjoyed writing. I enjoyed researching. I enjoyed that aspect of the law. And so I always knew that wherever I landed, that's what I wanted to do, was the brief writing and the analysis and that type of stuff, and the client counseling as well. Never wanted to be in a courtroom, and thank God never ended up in the courtroom. All that.
I wanted to be a litigator until I found
man.
out that litigation's like one trial a year. Nothing goes to trial. 95% settle.
No, and it takes a special personality, and you've got that personality. I do not have that personality. I have the opposite personality, so that was not my thing.
We would have been a good team, Brandon. A really good team.
Probably so, yeah.
All right. So you get out of law school. Like, where'd you go to first?
I went to Scopolitas first, so I did my internship at Scopolitas. Even before I went to law school, I was interning there. I benefited from nepotism. I'm going to be honest with you.
Don't we all?
But yeah, I mean, it was a great experience. I'm glad I had that opportunity. Got immediately into working with the largest motor carriers in the country, and we didn't have that many folks at the firm that were working on DOT safety and compliance, the DOT regulations, and so it just was a natural fit for me to go that way because it doesn't involve a lot of litigation. So it's where I wanted to be anyway, and landed there and never looked back.
Well, I think for a lot of the people that are watching this or listening through our podcast, Scopolitas is not something that's super well known unless you're in the transportation and compliance. Can you talk just a little bit? What is Scopolitas? What's their wheelhouse? What was that like?
Yeah, it's a transportation-specific law firm, the largest transportation-specific law firm in the United States. I think now they probably got around 100 attorneys nationwide, offices all over the country. I was based in Indianapolis, which was their headquarters. And we had attorneys that all we did was represent primarily trucking companies, but also brokers and shippers, everybody in the supply chain. And we did transportation-specific law. So we had some attorneys who did litigation, transportation-related litigation. We had others that did mergers and acquisitions for transportation companies. We had some that did employment law for transportation companies. My niche was always DOT safety regulations.
Well, I love like the M&A stuff within transportation. It's because like from my background, from my father's day at Roadway and just the industry before deregulation, like you couldn't grow but for acquisition. Like these lanes, these routes, you couldn't access those unless you bought somebody. So M&A and trucking have always kind of been hand in hand. And it's fascinating to see how it's gone. So how long were you with Scopolitas for?
I was there 10 years.
Okay. And then you said, I want to do my own thing. Like what made you do that special kind of crazy?
It was in the middle of COVID. It was right early on in COVID. And everybody was kind of reevaluating their life at that point, I feel like. Right. And, the other point I didn't get to a minute ago, but before I even went to law school, I had owned a business beforehand, a video production and graphic design business.
I didn't. That's incredible.
Yeah, all the way through. So all through high school, all through college, all through law school. That's what I did. And I did that for many years, and then I just kind of put it down. I started practicing. And so here we are thrust in the middle of COVID, and I'm sitting at home, working from home. And I had a lot of clients at the time that were asking me for resources for training for like their safety folks. Like, where can I go get training videos on how to understand these regulations? And I just never had a great place to turn them. And I started thinking, well, I could probably build this stuff. Number one, it would be fun. I enjoy that type of stuff. And number two, I feel like I'm uniquely positioned to be able to develop that type of stuff. So pulled the trigger on it, broke off on my own 2021, started Trucksafe, and haven't looked back. That's where we're delivering all kinds of DOT compliance content YouTube, LinkedIn, online courses, in-person conferences, everything. So.
I love that. I've referred as many people as I can to follow you and what you create, because what you do is generally gatekept by every lawyer who's like, I'm not going to tell you how to comply. Come pay me a bunch of money and I'll do it. Were you using like Canva? Like what kind of graphic design work were you doing?
No, I mean, legitimate graphic design stuff. So Photoshop, Illustrator, all those things.
That's incredible.
I mean, that's always just been fun stuff to me. So I don't even view it as work. It's what I enjoy doing. And so now it's the perfect mix of things. Like I get to do what I love while still using the knowledge that I've gained over the years in this particular industry. So
I couldn't agree with you more. Like I kind of stumbled into content creation because my kids were so enamored with it. I'm like, you're 5, you're 6, like you're not going to make content. Like dad will give it a try and we'll see if people pay attention. And it's one of the most rewarding things out there. Like it is creating something, the time you spend, the time you invest, and then putting it out there. Is that like what makes you really motivated within TruckSafe right now, is creating this helpful, illustrative kind of stuff?
It really is. Going back to when I was doing the video production stuff full time, I mean, we were videotaping weddings and stuff like that. And that got pretty old pretty quickly. But so I'm glad I'm not doing that anymore. But this type of stuff where I feel like I can actually put my experience, my knowledge on a particular topic in a form that is interesting to develop and send out into the world. I really enjoy it.
Now, how did you convince your family that, hey, I'm going to leave this world-renowned transportation law firm and I'm going to make a consulting company where I'm going to create content and interesting, like educational stuff? How did that conversation go?
Didn't take much convincing. I mean, it took several years of me thinking about doing something like this before. It wasn't just a off the cuff type move for sure. But I mean, my family's always been supportive of whatever I wanted to do. And so it didn't take a lot at all.
Do you miss the billable hour? Does that come back and go, man, I wish I could bill a 0.1 for
Has
this?
anybody said that they missed the billable hour? I don't think that's ever been uttered in the history of the world. No, I don't miss that at all.
Were you guys a 0.25 minimum charge or 0.1 minimum charge? Oh, 0.2. See, that's what tells me you're not working with insurance companies, because insurance companies will never allow a minimum 0.2.
They will if they want the work done, I suppose. But
that's fantastic. Yeah. So, okay, let's talk a little bit about TruckSafe. So what does TruckSafe do for motor carriers? When do they need to talk to you? When do they need to be thinking about the kind of stuff you dig yourself into?
It's evolved over the years. So when we started out, my main thing was online courses for safety managers, because that's the thing I saw a need for that didn't exist, at least as far as I could tell. So we started out with that. We still have our TruckSafe Academy, which is all of our online courses that are developed specifically for safety directors, safety managers, and folks in a position of having to manage regulated drivers and trucks, those that need to understand the regulations to be able to comply with them. So that's a big part of what we do. We offer those courses now through TruckSafe Academy to fleets of all types and sizes. Over the years, though, like I said, we've evolved, and so we do. We also just do normal DOT consulting work. So we do mock DOT audits for carriers that need it. And we do those both through our law firm and through TruckSafe, kind of depending on the needs. But we do a lot of that, and then we do in-person conferences. You and I were talking about this before the show. We've got our boot camp, fleet compliance boot camp. We've got a couple of other things that we just recently launched, one of which is our managed services company. This is where we're actually taking on the burden of keeping regulated driver files and vehicle files and managing them on behalf of the trucking companies that want us to do it for them.
That's that's really interesting. What I like when you first kind of outlined TruckSafe and how people can work with you. I'm a maintenance guy by training, by heart. I believe in preventative maintenance. It's better to be on top of things and be proactive than reactive. So many motor carriers on the compliance side run a business that's more reactive. And I fundamentally believe that a fleet that is operating today should be proactively working with someone like TruckSafe to kind of say, hey, just take a quick look. Like, am I doing everything all right? Like a mock DOT audit. Well, how intense is a mock DOT audit?
We try and make ours simulate as close as we can a real DOT audit, because if you think through what's the point of this, we want to know how we would fare if the DOT were knocking on our door. So there's a playbook that the DOT uses to conduct these. They pick what sample of records they want to view. They're not picking randomly. They're picking your worst performing drivers and your worst performing vehicles, and those who you're going to be judged against. And so we do the same thing. We simulate it. We simulate the time frame. We simulate the sample sizes. We simulate the actual audit. If you want us to come in on site, we're sitting there for 3-4 days, whatever it takes.
Yeah.
And going through your records and interrupting your business day if you want us to, obviously. And then we issue a report. And the benefit of doing that, one of the many benefits is, unlike the DOT, we're not just pointing out all of your problems and saying good luck to you.
That's right.
We're pointing out the problems, and then we're saying here's a recipe for how you fix these problems, because that's ultimately what you're paying for is,
right.
Hey, how can we get our arms around these issues that are causing us to have gaps in our DOT records?
What is an interval someone should think about for doing something? Maybe not as intensive as that, but just like having a review of the systems, technologies, processes. Is it an annual thing? Is it every other year? What would be a cadence you think would be reasonable for a motor carrier?
I would say that in-depth of a review, I would say every year or two is probably sufficient, but certainly that's not the end of the story. As you said, it's something I'm constantly preaching, is the need to be proactive.
Yeah.
And you can be proactive in ways that is not that involved. It's very easy, for example, for motor carriers to be tracking their safety metrics that are available publicly, most of them. So like your CSA roadside inspection data, your out of service rates, your inspection selection system score, those are the things that others are looking at, your customers are looking at, your insurers are looking at, the DOT's looking at, the plaintiff's bar's looking at. If you don't know where you stack up, you stand no chance. So at minimum, you should be keeping tabs on those things, because those things are painting a picture about your compliance and your safety. And if they are showing, or if they are telling a story that you're not a compliant carrier, then now's the time to get control of that before it balloons into a big problem for you. So.
And to build off of that, I'm going to use a case that we all are familiar with on this show, and you've talked about it too, is that Werner Enterprises case down in Texas. That is the most horrifying thing you can possibly imagine. And when you are trying to understand how does a motor carrier be found liable, for those who haven't familiar with the case, the story is a driver for Werner was operating a commercial vehicle. Their trainer was asleep in the berth. They were under the posted speed limit. Another vehicle lost control, crossed the median, like 10-yard median, collided head on, and Werner was found liable to a tune of over $100 million. I think it's 130 now with the interest. But the point of that is that plaintiffs' bar, as you mentioned, are looking for pattern and practice. Let me move away from this bad day for a driver and say, let's look at the carrier's processes, and then we're going to paint that picture. Is that something you work with your motor carrier partners to understand, how this is evolving?
Yeah, we do. So patterns and practice is a big thing of what we do, and policies as well. Policies can cause those types of issues as well. And so going in there, getting an understanding of, because that's what the DOT is doing as well, in essence. They're not just looking for the ticky-tack violations. They will certainly point them out as they find them. But what they're trying to ascertain when they're auditing your records is, does this carrier have sufficient safety management controls in place to maintain compliance with our regulations? And if there's a breakdown in those controls, then it's going to lead to bad outcomes. Now, the Werner case, there's only so much you can do.
There's nothing you can do.
There's nothing you can do in that case, and that says something bigger about our justice system, I think, that needs reformed. But putting that aside for a second, from the motor carrier's standpoint, you have to know that you have a big target on your back, and that target is going to be exploited. And the easier you make the plaintiff's bar's job, it's just going to be potentially disastrous for you. So you have to take every step you can to keep that from happening.
Well, let's talk about that target for a second. So my understanding is, 1980 Motor Carrier Act, that deregulated the industry. Lots of interesting things came from that. But one of the interesting things is the minimum insurance required to operate a commercial vehicle interstate. And that minimum insurance requirement was $750,000. It still remains to this day.
Yep.
$750,000. There is a bill in Congress. It is, I think the name is very interesting, that Fair Compensation for Truck Crash Victims Act. You know what they're trying to get to.
Yeah.
And that has pushed out a potential for a $5 million insurance requirement. Now, there's very few things OIDA and ATA agree on ever. And that is not one of them. They do not want that to happen. Do you think as an industry, we're underinsuring our motor vehicles?
I think we probably are, but I don't know that there's a great solution to it because of the position that we're put in. So just looking at that Werner case, here's how it plays out. We get these outrageous numbers. Our society becomes desensitized to these huge numbers that have no bearing to the actual, in most cases, I will say, have no bearing to the actual damages suffered in the case. And so what does that do? That concerns the insurers, and then it jacks up the premiums for the commercial auto liability insurance to a point where even with the current level limits, it's unaffordable for so many motor carriers to even get $750,000 worth of coverage. Imagine what the premium's going to be if they have to get $5 million. It's going to put them out of business. So unless we can get to a point where we have reform that does away with these crazy, outlandish outlier cases, and we get to a point where the insurers can insure us at higher levels for less of a cost, I think then at that point, that's where we start to we can have the conversation of raising the limit, making it more affordable for a broader base, and then it works to everybody's benefit because now we have more motor carriers with higher levels of coverage that could answer for most of the damages that are sustained in those accidents, but nobody thinks that way. So
I'm totally there with you. I think my opinion is I don't want to see an increase necessarily of $5 million. I would love to see maybe carriers adopting umbrella policies above their initial 750, maybe an extra million or two. But to your point, medical costs are not going down, and plaintiffs are finding a lot of money in these transportation companies.
To the point where it is so lucrative to be involved in these cases that we are seeing fraudulent situations. I mean, the Louisiana case is the perfect example that's been going on for a couple of years, where now I think there are like several dozen people that have been implicated in criminal charges for setting up an accident involving a trucking company in order to get the payout from that, including lawyers who have been criminally charged for this, including third parties that are financing this type of litigation. It's just absolutely crazy.
Anecdotally, when I was with my father's company, we had a fleet of mobile service trucks. I remember vividly in California, a vehicle that was in front of our service truck was driving on the road and just went to park, hit the reverse, and backed into us because there was a rebuttable presumption if you're the one who gets rear-ended that you didn't do anything wrong, and it's everywhere. All right, let's move on the regulatory side from not insurance requirements. Let's talk about speed. My goodness, do I love talking about speed. So can you kind of give me an understanding? FMCSA has talked about speed regulation. What is happening, and what do you expect to happen in the next period of time?
FMCSA and NHTSA both. This has been a joint rulemaking between both FMCSA and NHTSA. NHTSA being National Highway Traffic Safety Administration, that's responsible for regulating the manufacture of new vehicles, including commercial motor vehicles. So this has been a joint effort by them both. Going back, I don't know exactly how long it goes back, but I know in 2016 is when they published the first proposal to mandate a speed limiter, the installation of and use of speed limiter devices for commercial motor vehicles. And since that time, there has been through the rulemaking process, they accept comments from the public and that type of thing, and that's how we do regulations in this country, at least federal regulations. And a lot of blowback on that rulemaking for various reasons, and it just hasn't gone anywhere since then. We've had the supplemental notice of proposed rulemaking. What they've never done to this point is actually set what the speed would be if this ultimately takes effect, and so that's where we're at now.
There was an initial filing, I think last year, that had the number of 68, and then that immediately got pulled. Like, no,
somebody made a mistake there.
Yeah, we don't want that. We know what we're thinking, but we're not going to talk about it. I would say this for people who think about speed regulation. Every single state in the union has speed limits like that. There's not an absence of regulation. They exist. There is a great case for going slower. better for your fuel economy, better for your motor, better for your tires, better for a whole lot of things. So there are motor carriers today that voluntarily do speed regulation. Yeah. But I look at this rule, and let's just take the number of 68. If you get a regulation like that, a trucking company will have to take that vehicle to a provider and have the engine reprogrammed. That's I'm sure there's some remote way to do it too, but that is a very expensive undertaking.
Yeah, I don't know enough about the rulemaking to know whether it has that type of provision where it's going to require existing trucks. Because I know, like, for example, the automatic emergency braking rule that is going to go into effect here pretty soon. We're expecting a final rule on that here soon. It doesn't have any retrofitting requirement for that one specifically. For the speeding one, I could see it maybe having something like that, but I don't know if it's in the current rule as it exists, the supplemental notice.
Yeah, my understanding was that it did have something that would go back in time, because all these trucks can be slowed down. But the thing about for drivers, like, one, people come to this profession because there's a level of freedom. Whether that freedom is actually there or not is kind of ambiguous. But the other part of it is they have the ability to exercise discretion as a commercial vehicle driver, operator. And it does take away some of that. I find there's a very good case to have them, but I understand why there's some reluctance to have more regulation. Speaking of the one you just brought up, tell me a little bit about that one. What is this rule, and what's going to happen for motor carriers?
The automatic emergency braking?
Yeah, absolutely.
Yeah, I mean, it's going to mandate automatic emergency braking. Obviously, the technology that exists to automatically deploy the brakes if the vehicle senses that it is a rear end is imminent. But these are only going to be mandated on newly manufactured vehicles, commercial motor vehicles, after a certain date. And that's going to be set by the final rule. So it's a technology that exists already. And it's one that exists in a lot of the trucks and passenger cars, frankly, that are being manufactured today. But in terms of mandating it of commercial motor vehicles, once the final rule is passed, it will set a date certain, and then vehicles manufactured after that date will have to have it, number one. And then from the FMCSA standpoint, this is how they normally do these types of vehicle equipment regulations. Is the FMCSA's role in that is to say, our regulations mandate that you motor carriers actually use that technology. Now that we have a NHTSA regulation that says it has to be installed in the truck, we need the modal agency, FMCSA in this case, to say, motor carriers, you have to use that technology. And so that's what we'll see when the final rule comes out.
Do you have an idea of when that final rule will take place?
No, should have done a better job preparing, I suppose.
That's all right. We're ad-libbing this, man. No. Well, let me ask this question. There's another reg that it's not been officially proposed as far as I know, but it has to do with underride crash avoidance for trailers. So we have this ICC bumper at the back of a trailer supposed to help when someone rear ends a trailer, doesn't get really severely injured. And there's a lot of talk about making this on the sides of trailers, like side impact.
There was for a while. There was a lot of talk about that. And I think it was on the FMCSA's regulatory agenda for a while. But as far as I know, that is no longer on the agenda. And I think the reason is it got a lot of blowback too. And so it is just not a priority anymore. I haven't heard any more talk about it being on the agenda. So.
When I was at the TMC, there's some conversation around that. And my understanding is, like, to retrofit a fleet across this country, it would be close to $1 billion. So it's a significant undertaking in a time when the market really doesn't quite support that, it seems like.
Yeah. So, I mean, that's kind of how we go along with FMCSA regulations, is things pick up steam, and then we open the comment period, the floodgates open, and then depending on the level of blowback that the agency gets, then it pretty much influences how likely that thing is going to happen or not. I mean, that's just the rulemaking process. So.
I mean, it's a political process at the end of the day. So there's absolutely some safety and regulatory concerns, but yeah, to the point of, like, if the people aren't talking about it, we're not going to push it.
Yeah.
What are some regs that are on the horizon that you're aware of that people aren't following or maybe not paying attention to?
There are quite a few that are slated for implementation either this year or early next year, and they're pretty significant ones. For a while there, a couple of years back, we had a lull in regulatory activity at the FMCSA, but it has picked up steam starting middle of last year and into this year. I would say the biggest ones that fleets need to be watching out for, at least from a DOT safety standpoint, are going to be potential changes to safety ratings. So these are the satisfactory, conditional, unsatisfactory ratings that some motor carriers have. If you've been through a DOT audit, a full one, then you've got a safety rating. But they've been toying around with kind of modifying the way that they rate motor carriers over the years. And they tried that last in 2016, got a lot of blowback. And so then it went quiet for a while. But it's back on the docket. And so we expect that later this year or early next year, they will proceed with some kind of revision to how they rate motor carriers. And a related regulatory development to that is changes to CSA, so how they score motor carriers based on roadside inspection activity primarily. They are in the midst of making some pretty significant changes to the methodology for calculating a carrier's CSA score. So reading the tea leaves here, they haven't said this outright, I don't believe, but I'm suspecting that they will make these changes to the CSA program, and then they will eventually come out with a safety rating rule that in some form or fashion probably ties that carrier's safety rating to their CSA scores, which is not going to be very popular among motor carriers. But
do you ever see a world where the brokers are going to be rated in any form or fashion? Is that a thing that could ever happen, or is that in the fanciful world of the impossible?
Everybody gets up in arms about brokers and fraud and that
double
type of
brokering,
stuff.
transparency
Brokering in the industry. And I'm a little bit sympathetic to folks that get up in arms about that. But here's the deal. I mean, they're looking for FMCSA to be their savior and come in and help them. And that's not what the agency does.
Yeah,
it's the Federal Motor Carrier Safety Administration. They don't care about your commercial dispute with the brokers. And so, no, I don't see any world where FMCSA comes in and heavily regulates brokers in that way, particularly after deregulation. I mean, that was the whole point of deregulation.
That's right.
It was a commercial deregulation. We, the federal government, are going to get out of regulating the commercial aspects of trucking and let the market take over. And that's what they did in the 80s and the early 90s. And so they didn't get out of the safety things. That's why we have the FMCSA. They're here to regulate the safety of the operation of these commercial motor vehicles, not commercial aspects. And so if you've got a commercial dispute with a carrier or with a broker, that's your problem to deal with, whether you like it or not.
Yeah. I mean, there might be a path with like federal investigators or state folks on criminal charges of fraud and that kind of thing. But to your point, I'm with you. I don't see much of a value in that. I'd love to get your thoughts on like broker transparency. So I think it's FMCS. I think it's like CSR 37.1.3. I could be wrong, but it has to do with like producing records of a brokered transaction.
We saw a little blip in this with FMCSA. I can't even remember what change they made about it, or maybe they just put a notice out or something like, I can't remember exactly, where they acted ostensibly interested in this issue. But it goes back, I don't think they're interested, and I don't think they should be interested. Again, that's another commercial aspect of trucking that the market should take care of. And if the market doesn't take care of it, then it's a private dispute between private parties that should be handled through the normal channels. But with that said, FMCSA, for whatever reason, still has some regulations on the books that could be considered commercial in nature, but it turns out they just don't enforce them.
Yeah, that makes sense.
And that's one of them. There's a lot of regulations. If you dig into the regulations, there's also ones on the content of bills of lading, for example, that never get enforced. And it's because for all of the reasons we've already talked about. It's FMCSA's mission is to reduce highway accidents, not to insert itself between transactions between private parties.
I have one. We didn't prepare for this one at all, but I'm really excited to get your opinion on this. So one of the cases I saw kind of developing was around hearing impaired drivers. So FMCSA and their driver qualification stuff has said, like, as long as you can read and write in English, you are okay to operate a commercial vehicle. We saw a case, again, I feel like I'm picking on Werner, but it's not. It's just they're the ones who ended up with that litigation. But essentially, they had put someone through a driving school who was hearing impaired. They had gotten the waiver from the FMCSA to actually operate that. But the company said, we're not going to hire you because our policy is not to hire hearing impaired, though you may hold a CDL and work for somebody else. Yeah. I think if I'm a plaintiff's attorney and a hearing impaired driver is involved in a catastrophic accident, I'm going to have a really good time. Like I'm going to be able to get something. So do you have any thoughts on something like that?
I mean, that's the risk you run as the trucking company in that position of having to make that call. I mean, even though we say this all the time, not in just this context, but it's like the rules are the floor. These are the minimum of what is expected of you to be able to safely operate. Does that mean you should stop at the floor? Of course not, because when we're involved in litigation, the question isn't just, did you comply with the regulations? The question is, did you act reasonably under the circumstances? And if you've got others, your peers, doing more than what the regulations require, then it's very easy for the jury or the court to decide you didn't act reasonably because you're not following the industry standards of what everybody else is doing. So it puts carriers in an unenviable position of having to make that call, particularly when you've got employment issues bumping up against the safety issues. This is a tension that exists in our industry that I wish didn't exist. It's not just this context. It's also the independent contractor status.
Yeah.
The more you do from a safety standpoint to try and get control of the contractors, the more that weighs in favor of them being employees.
Absolutely.
And that's a tension that should not exist, but it does exist. And it's something we have to deal with.
I look at, like, I say this often, but I think the greatest innovation in supply chain outside of containerization in the 50s and 60s, I think, was the independent contractor model. The idea of saying, I want to control you like an employee, but I don't want to pay for your meal periods or your health insurance or your unemployment or your workers' comp. And I go back to my father. So my dad was like the cutting edge of innovation. He was a dedicated provider of maintenance for RPS, Roadway Package System. What RPS wanted was Greg Leffler to be the person that they controlled. And Greg would hire all the mechanics and management. And when anything happened, it would be, okay, Greg, you got to get out of here.
Right.
How are you seeing this evolve now? I mean, there's the AB5 stuff in California. We have some new stuff in the feds. How are you helping your clients navigate?
I dabble in this area. I mean, when I was at the firm, I did a little bit of the IC classification litigation, particularly in the unemployment realm. And it's, it's continuing to, it's a very politically charged issue, unfortunately. And so it leaves carriers in the middle of that issue. Now, I'm not saying that there aren't situations that warrant a paternalistic view from a state government or the federal government where they have to come in and protect a worker, but that is largely was never my experience. I've worked with a lot of the largest trucking companies in the country that have IC fleets. I've talked with hundreds of their independent contractor owner operators, and the vast majority of those guys want to be in that, guys and women want to be in that position. They enjoy the freedom that comes along with it. And when you've got states like California coming in and saying, no, actually you can't be that, even though you want to be that. It's a miscarriage of justice and the entrepreneurial spirit that a lot of these folks have. And so I think we are throwing the baby out with the bathwater in a lot of these cases.
What I will say, which I love, one of the points you brought up is the context of when you dealt with those was around unemployment stuff. And I want to mention this for everyone watching. Like, the thing is, these cases about misclassification generally do not happen when the feds come knocking on your door and saying, let me see how you classify. 99% of the time, it is a contractor who has either lost their job or has been injured. That's and right. They say, how do I get help? Do I go to workers' compensation? They make a claim. Workers' comp comes and looks at how you've characterized that person. Then they make a determination, or unemployment. So
or
it's
one other. Which is the plaintiff's bar getting wind of a large independent contractor fleet and then just pursuing them for
and that's damages. A really important point, because misclassification, if you are found liable for misclassifying, not only are you paying back wages and back benefits out of your pocket because you can't buy insurance for this, but it is attorney fee shifting. And if anyone takes anything from this, it is, if there is ever an attorney fee shifting provision, either in statute or contract, pay attention, because if you lose, you're paying your lawyer and you're paying theirs. And that is bonkers.
Yeah, the incentives are just screwed up in a lot of those cases. So yeah, I mean, those are the common contexts. It's usually a state, and that sets up another issue, which is we're a very interstate industry. We've got trucks operating all over the country. So why in the world should I have to worry about potentially 50 states' treatment of who is an independent contractor or who is not? It's unmanageable for a large trucking company to do that. It should be an issue suitable for federal preemption. And the states are they take a paternalistic view over folks that they, for whatever reason, political pressure, usually think aren't capable of protecting themselves, and they feel like they have to insert themselves to protect those workers. So, like I said, some cases maybe they do, but those are the egregious cases that they should worry about. They should not be throwing the baby out with the bathwater.
I couldn't agree more with that. And the thing you mentioned, like, so most states view labor as their domain. They're not very interested in the feds coming in and doing it. They'll agree to federal minimum wage. They have no choice. But this idea of the federal government coming in and saying, this is the test that we're going to use. Because for everybody who's watching, this is about tests. It's about like an ABC test, an economic realities test. It's a fact intensive investigation. And every state, it's different. Or at least there's some piece to it.
A lot of them have exemptions that are specific to our industry for owner-operators specific. A lot of the more conservative states, you'll see that they have baked in exemptions that say if you're an owner-operator in our state, then you're an independent contractor as a matter of law for unemployment and or workers' comp purposes. You don't have to worry about those states. But then you've got that same driver who's traversing through those conservative states into states like California. It's like that's the nature of our business. So when he's in a conservative state, there's something different about his relationship with me than when it's just those states, the more liberal states, they want to have that paternalistic control over that relationship, which they do out of some misplaced sense of, this is just my opinion. Honestly.
Yeah, they think they're helping. They
say that they're helping, and I just question I question the motives, and
I would love to get your thoughts on the California Air Resource Board. So CARB is this thing, again, if you're not in supply chain, you have no reason to care about CARB, at least initially. Yeah. But the California Resource Board is this thing that sets, essentially emissions and environmental stuff in California. But where CARB goes, so goes the world.
Yeah, I don't get it. It's the tail wagging the dog there. I mean, whatever CARB does, somehow it trickles up to the federal EPA. I have a general sense of how the Clean Air Act works and how the EPA has to approve the state plans like CARBs. But somehow or another, things have gotten so turned around with that now CARB is essentially dictating the mandates that then get pushed out to the rest of the country, which just makes no sense to me.
It's an intellectual contagion. And it just, once it starts there, it starts permeating throughout other states, other jurisdictions. I'm curious, like, if you were looking to start a trucking company today, what are the biggest things that people make a mistake on when they're operating the commercial fleet? What is the thing that they need to not do, but they seem to continue to do?
Well, I mean, from my perspective, I'm always looking at the DOT safety side of things. I just think they get excited about going out there and doing the thing that they forget to put the initial processes and policies and procedures in place in the first place. And that's what contributes to this reactionary nature of our industry is you get out there, you start operating, everything's looking good until it's not. And so the better way to do that, of course, would be to plan for things. And part of the planning is not just setting up your customer contracts and setting up the LLC and stuff like that. It's making a plan for how am I going to manage all of these safety regulations that I'm required to comply with. And if you don't do that up front, then inevitably what's going to happen is you're going to start incurring violations, or you're going to get involved in a bad accident, and then you're not going to have any of those things, and then you're going to get shut down one way or the other.
It's one of the reasons why I always advocate to new operators is have a maintenance escrow account. Do not plan that you'll fix it later. Just take part of your money and put it in a thing that is just for maintenance, and that's it. That's all you got to do, and that can save you a lot of trouble.
It says something bigger about our society. I mean, we are so interested in the today and the instant gratification of things. I mean, this just bleeds over into our industry. We are more worried about the money we can make today. We are not thinking ahead to, hey, what can go wrong in the future? How can I plan for that now? It's just not something that we do enough of.
You're exactly right. We live in an environment where it's quarter to quarter, month to month, day to day. It has to be a longer term perspective if you want to last in this business. And some people can last and some cannot.
Some are lucky.
Yeah. Are there regulations you wish we had? Like, because as lawyers, we're reacting to other people's ideas of regs. What regs would you want to see happen?
That's a good question. It's one I don't know that I've answered in a long time.
I asked the tough ones, Brandon. Only the
Yeah,
toughest.
I feel like I'm on 60 Minutes or something. I can't think of a regulation off the top of my head that I wish existed.
I'll give you one. I'd like to get your reaction to
Yeah.
it. So FMCSA mandates one inspection a year. You have to take your commercial vehicle, get it inspected, and then it's good to go for the year. California, on the other side, has a BIT program. It's quarterly inspections. I believe, and this I think is very controversial, that we should require 2 inspections a year.
But let me ask you this. Do you think requiring 2 inspections a year would fix the issue? I mean, because what you're getting at is even with 1 inspection, we still have a high occurrence of vehicle out of service rates, right? Like upwards of 20%.
Absolutely.
And so my question to you, though, is more regulation the answer? Is that the solution to the problem? If we inspect it one more time a year, are we going to drive down that out of service rate or not?
My feeling is the barrier to enter this business is too low. I think it's easy to get a truck. It's easy to get a CDL. I think it takes like a month or 2 months to get a CDL. And with the leasing setups that we have out there, you can become a driver, have your own business, and then you don't do the right stuff. So you're very right. Like this would be adding regulation, adding cost, and not knowing for sure if it'll have the desired outcome.
Here's what I think. I've actually written a pretty detailed article on this, and I think it goes along with what we're talking about. I think we should do a better job as federal regulator. I'm not one of them, but I think federal regulators should do a better job of when they implement regulations, taking an inward look at those regulations after a certain period of time and figuring out if it is actually accomplishing the goals that they had set out for it. And if it's not, then they should be more willing to roll back those regulations if it turns out that that wasn't the solution to the problem. We don't do that. Right now, we implement regulations. We have some kind of semblance of a cost-benefit analysis in the initial rulemaking. We impose the regulation, and then that's the law of the land. We just go along with it. Occasionally, you'll see some rollback of regulations, but it's very rare. Once the regulations exist, they've got you now.
Yeah, ELDs aren't going anywhere.
No, they're not going anywhere. And so even despite data, I don't know that I necessarily agree with the hot takes on this. There is data out there to suggest that after the implementation of the ELD rule, the instances of fatigue driving haven't necessarily gone down.
Yeah, Jason Miller has done a lot of research on that issue, and I think I'm paraphrasing, I could be wrong. I don't think the safety has been proven out necessarily, though there's a lot of value in connecting things anyway.
Yeah, but the way I kind of look at it is I'm not so certainly safety is at the heart of any kind of rulemaking that the FMCSA implements, or it should be. But I think one of the big things that the ELD mandate actually does, I think it has done a good job of, is sussing out log falsifications.
Yeah.
I mean, that's the big point of the ELDs, is to cut down on instances of drivers and carriers falsifying their logs and trying to get around the substantive hours of service rules. And so I hear folks saying, oh, we're seeing more log falsifications now with the ELD. I'm like, yeah, that's the point, is to discover more log falsifications with the devices. They are helping us identify situations where there is a potential concealment of hours of service rules. And so in my view, it's just more information, more tools available to us to identify issues that could then lead to potential safety issues. And so I think that's one of the big purposes of the ELDs. And I think it feels like they are doing a good job of that. Whether they ultimately then lead to fewer fatigue crashes, I think we're going to have to give it more time. But I think we should do that analysis. I think FMCSA should commission studies over time to see, is this actually cutting down on accidents or not?
We need more subscription services for truck drivers. That's the feeling that I have.
Yeah, one more monthly fee.
Yeah, well, and to back up on the twice inspections, I will say this: most motor carriers do not inspect things once a year.
Yeah.
Most of the enterprise over the road motor carriers are doing a lot more than just an annual inspection. So to your point earlier, the regulation is the baseline. Like that is the minimum. Doing the minimum might not always be in the best interest long-term for a trucking company.
Let me ask you this. Is this one of the proposals with the proposed CSA changes is to split out the vehicle maintenance category into 2 subcategories, a vehicle maintenance and a vehicle maintenance driver observed. The idea being that if you have a high vehicle maintenance driver observed category, then more than likely the root cause of your problems is that your drivers aren't doing a thorough enough pre-trip inspection. These are things that should have been patent to them. Light bulb out.
Absolutely.
Low tread depth, the things they should be checking. Whereas if you have a high general maintenance score, then the idea is that it's more of a mechanical problem with your fleet. And I see what you're saying. More inspections, maybe that helps us on the mechanical side. But what I see with a lot of our carrier clients is that it's often a situation where drivers are just not doing thorough enough pre-trip inspections, and we as the carriers are not holding them accountable to doing those things.
This is a fundamental challenge we've seen all over the place for decades on pre and post trip inspections. We want drivers and we require drivers to do it, but they simply don't. One, generally they're not paid to do it.
They're not incentivized to do it.
Exactly. If you don't have an incentive to do the right thing, you're just not going to do it. I worked with a lot of motor carriers that had independents pulling with their owned trailers. So my customer had the trailers and then someone was moving them. And we would have my mechanics inspect those every 10 days because they just didn't think the drivers were doing it. But I think that's a great idea because at least at some level, there should be a reward for truckers that catch things as opposed to accident non-report. Oh, it was like that when I got there. I don't know.
Maybe. I don't know. There certainly shouldn't be a disincentive for not doing it. Should there be more incentive? I don't know. I'm kind of the mind. This is more going back to we are living in the moment. We're not looking at the long game here. If I'm a commercial driver, my incentive is that I want to be operating a safe vehicle so I don't kill somebody or I don't kill myself. And so my incentive, if I'm doing things correctly, is that, hey, I need to do this for my own sake and for the sake of those I'm driving with. And so I kind of see it that way in one regard. But at the same time, like I said, we don't want to disincentivize them. So when we're paying them by the mile or whatever, you can kind of view it as almost a disincentive for doing that type of thing. But
what do you think about the robots? So I'll give a little bit of background. So we had the advanced notice of supplemental proposed rulemaking, which is it's a mouthful. I love legal jargon. And this was around level 4 and level 5 automation. Level 4 automation is a remote operator. So someone is operating the vehicle remote, like a drone pilot. And then level 5 is a remote assistant. So someone who can't take control, but can offer information to regulators or other human beings on the road. What do you think about this? Are we going to see something in this year?
I think we need to, because these operations, whether you believe it or not, are actually out there operating.
They're happening right now.
They're happening right now. A lot of folks come to me and say, no, we don't believe it. It is happening. I've ridden in the trucks that are doing this, particularly in states like Texas.
Yes, with safety drivers, but you're absolutely right.
Even non-safety driver operations.
That's incredible.
In commercial motor vehicles, fully loaded commercial motor vehicles with no safety driver. And so we're going to get to a point where these are going to become more and more prominent, and we're going to be behind the 8 ball at that point. And so FMCSA and NHTSA need to get their stuff together and need to push out regulation. I don't think anybody's in the industry is saying we don't need regulation. We don't want regulations in this area. I think even the autonomous vehicle manufacturers are saying, we want some common sense regulations to govern this. So they just need to get their stuff together.
An interesting data point on all of that was last year there was a bill in the California Congress that was going to require a human being in any autonomous truck, and Newsom vetoed it. So this is coming. And I mean, to your point, it's here now, but the longer we delay, I think it just creates a thing where, like every other problem in every industry, technology outpaces our ability to regulate it. And we don't want to be in that position.
Yeah, I mean, because then you're constantly having to catch up to the technology, and it's a game that cannot be won. So, at minimum, they need to come out with a basic outline of what, because right to this point, like you said, we're at I don't even know. Are we at I don't even think we're at a supplemental notice of proposed rulemaking. I think. You said we're at a supplemental advanced notice.
Yeah, exactly.
Yeah. So we don't even have a framework for the regulation. No. That's just them saying, "Hey, we're thinking about."
Yeah, we're still thinking about it.
So it's time to move on to a notice of proposed rulemaking. And I don't have any insider information to know where that thing stands. Hopefully somebody's working on it. But
I mean, I know that the Commercial Vehicle Safety Alliance is deeply involved in trying to figure out ways to regulate this, like whether you need more inspections, you need to disclose a whole bunch of other stuff.
Well, if you kind of think about what, sorry to interrupt. If you kind of think about, I've kind of gone through this thought exercise too. It's like once those become more more prominent. We're less worried about driver issues at that point from a regulatory perspective, right? So we've got a whole body of safety regulations devoted to driver qualifications. Those become less relevant, and now we're talking almost exclusively about vehicle maintenance and the condition of those vehicles and the technology.
But like a level 4, what kind of qualification must a remote operator go through? Like, are you drug testing the operator? Like, there's so many unanswered questions, but they will be answered in our lifetime for sure, but probably in the next few years. Do you think, like, once there is, let's fast forward, the regulations are in place, the safety case for autonomous has been done, what happens to the driver? I mean, I see middle mile, I see yard trucks, but what do you think happens to the driver in a world of autonomous trucks?
I think we continue to have normal operations, driver operations, sitting alongside driverless trucks, at least for the foreseeable future.
Yeah.
I don't think it's going to be any kind of swift change where everything transitions over and all of a sudden we've got all these drivers without jobs. I think they will coexist for a long period of time, if I had to guess. And then, we'll see how the autonomous operations go and whether they're saving us money or not.
How often do you say in a given day, it depends?
That's the classic lawyer response.
That is the classic.
I'm trying. I've been trying for the last 3 years to get out of the lawyer game altogether. So I find myself saying it less and less. But once it's ingrained in your brain as the response to every question.
That's right.
It's just the natural response.
Nothing's yes or no. Everything.
I say it to my kids all the time still. So
just give me some more additional facts, and we'll make a decision based on all those facts.
It depends on what your mom thinks. Usually.
No, but we're getting close on time, and there's a couple questions in the mix. And I'll dump to some if I have a chance, but I want to ask you this. So you mentioned you work with brokers to an extent, and one of the biggest legal issues facing brokerages, at least as I can tell, is this idea of broker liability. And so the idea, generally, there's two theories that we typically see. One is a truck has an accident and they come to the broker and say, you negligently hired them. You weren't careful enough. You didn't do it right. You should have been better. And if you would have been better, we wouldn't have had this accident. And so therefore you're on the hook. And the other argument tends to be more of like I'm going to break into some lawyer stuff. Respondeat superior. Hey, you were actually an agent.
Joint employment type.
Joint employment, exactly. What do you work with brokers to understand what's happening in the federal system? Like, how do you think about that?
I try not to. I try and stay out of that, but I understand it because it goes part and parcel with what we're doing, and it goes right back to that insurance issue we talked about. There's not enough insurance to cover the damages in a particular case. So where does the plaintiff where do they get made whole? Yeah. They get made whole by going up the chain. That is the next logical step. The carrier doesn't have enough assets. It doesn't have enough insurance to cover my damages, at least what the plaintiff's attorney is telling my damages are. So we're going to go up the next step. We're going to go up to the broker, and then if we can't find it there, we'll go up to the shipper. And that has gotten some, as you know, that has gotten some legs in various jurisdictions, but other jurisdictions have shut it down, including the Seventh Circuit. So. It's I think it goes part and parcel with that insurance issue. And until we get that insurance issue figured out, I think this is going to continue to be a problem unless SCOTUS steps in and gets the circuits to play nice with one another, but they've already turned it down. So
yeah, they've turned it down at least twice that I know of. So they turned down the C.H. Robinson case in the Ninth Circuit, which was C.H. Robinson could be found liable for what happened in that case, and then almost identical facts in the Seventh Circuit, like you mentioned, the Global Trans VE. They also said, no, that's not something that's possible,
or unless Congress steps in and legislates in this area, which is certainly another possibility that has been tried, as I understand it, dozens of times, and it just has never gone anywhere.
I cannot see the world where Congress wants to get involved in our industry. I mean, they have their ideas. My last question, because again, we're getting close on time. There was we haven't even talked about this. So the FTC last year put out proposed rulemaking around banning non-competition agreements. This was a really interesting thing. 20,000 comments were filed. Interestingly, the ATA filed a comment, an 8-page document saying we love non-competes. Now they piggybacked off the U.S. Chamber of Commerce that said, hey, we think there's no grounds for this. It doesn't have the right, the authority. But like, what do you have you had to deal with any of that? What do you think about that?
That's your world, Matt. I stay out of that one for sure. But Yeah, I could see a little bit of both sides on it. I'm not familiar with ATA's comments. I don't know what their justification was for it. I can't imagine a world where it makes sense to have non-competes with truck drivers.
They never built to enforce those. For executives, there have been drivers who have seen those, and even independent contractors have gotten those, and that's made them become employees.
For executives, it makes more sense to me. Like I said, I don't get involved in it in any depth at all, but just conceptually, it makes some sense from an executive standpoint. But the lower you go down in the totem pole, the less sense it seems to make.
Absolutely. Well, we're at our time. Brandon, where can people find more about you and access to the content that you create?
Trucksafe.com is our website. We're posting all of our content on LinkedIn and YouTube, and we have a podcast, our own podcast called Trucksafe Live, wherever you get your podcasts. So yeah, pretty much any of those places.
Well, I will make sure to put all of that in the show notes. I'm going to kick you off. Stick around in the back if you can. I'm going to say my goodbyes to everybody, and we'll catch up here in a minute.
Thanks, Matt.
Thank you for coming on, Brandon. So there you go, folks. That is Brandon Wiseman, CEO and founder of Trucksafe Consulting, as well as a partner at the Childress Law firm. Here's what I'm going to tell you. If you are trying to understand how to navigate this industry and you are wanting to understand what it takes to operate a commercial fleet, you have to check out Trucksafe. Brandon is an incredible resource for people all across this country. If you're a shipper, you're a manufacturer, you better understand at least some part of what happens when that freight leaves your custody and control and gets put into that trailer and moved across the country. The more you know, the better you can plan around all of the things that are going to be happening in transportation, from speed regulation to advanced safety systems and braking systems to automation. Everything is about law. Everything is about supply chain. And when those things intersect, you better know that I'm going to be there. Now, I have to say thank you once again to my great friends and partners over at DAT, Dial a Truck, Dial a Truck. Dialing a truck was the idea of going to a load board, a physical thing on a wall at a travel center, and saying, where am I going to next? DAT's been helping truck drivers safely get home and find profitable loads, trying to eliminate empty miles. Oh, I do love my friends at DAT. Now, if there's anything else that you want to do for me that would be helpful, would be share the podcast, like, subscribe, do the things that the robot tells you to do. That helps me, help you to get better content. And we are always trying to find the best stuff we can to bring to you. Thank you again for tuning in. There's a lot of people here today, so I appreciate you. A lot of comments. We'll respond to those comments. But as always, I appreciate you. Have a great day. Thanks again. And then I hit the button and it goes away.